legal significance. And the idea there is that we don't sign or execute documents that create a legal obligation unless the information contained within them is factually accurate. So if I sign a promissory note promising to pay someone $30,000, for example, and I put my signature on it, that promissory note creates what? Creates a financial obligation. It has independent legal significance. And because it does, and by independent legal significance, we mean independent from the cause of action or the issue at the trial in question. If it has an independent legal significance, we're going to let it in because there's great indicia of reliability there. The thought process is, I would not execute a document that creates legal significance unless it was true because of the impact that it could have on me or mine. Yes, ma'am? No, because sworn notarized statements don't create a legal obligation to you. Because when I swear a statement, maybe, potentially, I'm creating the potential that I might be charged with perjury or false swearing if you have a false swearing statute in your particular jurisdiction. But I'm not creating a financial obligation or a contractual obligation. So if you think of documents of independent legal significance as dealing with contractual obligations or, what else? The transfer of property when someone dies, when I'm dealing with probate or intestate and things like that. That's why, for example, a holistic will. I know, I apologize for talking property for a moment. But a will that's been written out by hand in many jurisdictions, that's considered admissible, right? It's never a hearsay issue there. It's clearly not a statement by a party opponent because the person who wrote the will is what? Dead. But because it creates an obligation for the disbursement of the inheritance, it has legal significance. Ergo kumquat, it's not hearsay. It's non-hearsay and it's admissible. Does everybody get these categories for non-hearsay use? Now this is important conceptually as we start to talk about hearsay. Everything that you do with hearsay goes into one of these 5 buckets. And if you can identify which bucket it goes into properly at the initial analysis of the hearsay issue, your odds of answering the question correctly greatly increase. That requires you to substantively learn every little piece that goes into each bucket and to have the ability to look at the situation in the call of the question or in the courtroom and say, that's what's happening here. Well, you will soon discover that I might have a situation where the hearsay evidence could be admissible under 804 or 803 and is also admissible under 801. If that's true, which answer is the best answer? The 801 is the best answer. Why? Because by operation of law we have excluded those statements from hearsay doctrine. So it has more power from an evidentiary perspective, at least according to the National Conference of Bar Examiners. Do I think it has any more power in the mind of a jury than from any other statement that's been admitted substantively? No. But that's sort of a picayune thing. Picayune meaning small, aggravating. That is often used to differentiate your knowledge of hearsay rules. Oh, by the way, about 5 to 10 questions on every bar exam have 2 correct answers. Just something else to think about. I don't do that on my exam, but I do allow you to explain your multiple choice answer. And if you miss the question, I'll go back and check. And if I agree with your argument, I'll give you credit for it. I have not done that once in 8 years. But I do it every time. Primarily because the questions that I use are modeled after the bar. And we have the ability to analyze our questions when we use them in previous years, so we can statistically determine whether or not they're valid. Most of them are. There are about 5 that are just, you want to beat your head against the wall every time I use them because I'm not sure what the answer is. Sorry. So, the threshold inquiry that I always engage in is this an assertion? We go back and look at 801. A, statement. Statement is an oral or written assertion, nonverbal conduct of the person, if it is intended as an assertion. So, is this an assertion? What does this mean? I don't know. This means yes or I don't know? Yeah, I think it's an assertion. What about nodding your head up and down? All right. What about extending your middle finger and not your other fingers and pointing it at someone? What about this? Anybody know what this means? Anybody lived in Germany? You can get fined by the Germans if you do this when someone else is driving. There you go. Very good. You've developed ability when you can swear not only in other languages but in other symbols. Why do I make that point? Because communication of assertions is also cultural. My father-in-law, God rest his soul, if he did this, he's Italian. You know what he was telling you? Or if he did this, or this, those all had real meanings. Now you had to understand the culture in order to be able to establish what those meanings were. If you don't know, marry an Italian person and you'll find out. Charles. I can't help it. It's a target of opportunity. It's not wise to let me know about your interpersonal relationships if you're in my class, because I am just incapable of not saying something once I'm comfortable with you. It's just not possible. There's a student right now who's dating someone that is amazing, and I have not yet fallen on this student to feast upon her idiocy, but I'm waiting for just the right time. Not that she should be concerned at all. Right, Liz? One of her buddies gave her up. That wasn't very nice. It happens. You remember that, right? No one in here is your friend. No, that's not true. That's not true. When I have nonverbal conduct that is intended as an assertion, think about how foundationally I might have to establish that it is a communication intended as a communication. I might need some foundational questions. If those foundational questions are not present, a hearsay objection might be sustained. If those foundational questions are present, a hearsay objection might be overruled. That's an interesting little tidbit to think about from a physical perspective. Did anybody catch how Terry McCarthy uses nonverbal conduct to manipulate witnesses on cross-examination? Has anybody seen that on his cross-examination tape in the ARC? Terry will ask you questions, the answer to which is yes, and even he will nod his head every time he asks you a question. Do you know how hard it is to say no to someone who's nodding their head up and down? It's very, very difficult. I mean, I do it with my children out all the time. You dropped your iPhone today, didn't you? You were out late last night, weren't you? You forgot to call your mother. You're grounded, aren't you? When you move the head, and when you won't know, it's the same thing. You didn't do that, did you? Now, we do these things all the time as human beings when we communicate. We will make gestures that accompany the verbal communication. It is so hard to do the opposite of what the nonverbal communication says. It's very difficult. Something to think about. So, if I'm in the hearsay world, I've got to be in 803, 801, 803, or 804. And what I want to talk about in the rest of class for today are these confrontation clause cases, and then I want to segue into 801.